Okay. Well, why don't we go ahead and get started? Um, let's see. So I am super thrilled to introduce Dr. Jennifer Steele. So Dr. Steele is a 25-year federal agent and licensed clinical psychologist with a focus in providing expert testimony about science-based investigative interviewing techniques, coerced or false confessions, and the dynamics of interpersonal crimes. She specializes in victimology, grooming, cognitive biases, and the power dynamics associated with sexual assault, the psychology of victims of sexual assault, as well as the psychology of suspects of sexual assault. She currently serves as Associate Director of Training and Research in the Behavioral Sciences Directorate at the Department of the Air Force Office of Special Investigations. Dr. Steele obtained her Bachelor of Science in Psychology from Northern Arizona University, a master's in forensic science from George Washington University, and a second master's as well as her PhD in clinical psychology from Fielding Graduate University. So, with that, I am thrilled to welcome my dear, dear friend, an incredible karaoke singer, an all around amazing human being, Dr. Jennifer Steele. And I want to thank everybody for tuning in. I'll turn it over to you.
Thank you so much, and thanks for inviting me here, and welcome to the group that is joining us. I'm just super excited that you asked me to present on this topic. This is I think it's a pretty incredible topic, and I'm a very informal presenter, so yeah, so if anybody has any questions, I don't know that I can see, but if you can, I don't know if there's like a hand raising thing or just chime in, frankly. We can just, I don't know how many of us are here, but if, yeah, it doesn't look like there's too many, so we can have happy to do informal dialogue as well. So we will get started. I was gonna ask just at the beginning if anybody that's on the call just has any basis or any background in this topic whatsoever.
I'm going to go ahead and let everybody talk if they'd like to. They would just have to unmute.
Yeah.
But in the initial conversations with folks, I think that it's just one of those topics we don't know a lot about.
Okay. Well, I think, and that's great. Yeah, no worries there. As we talk about it, I suspect that
Oh,
oh,
hey Susan,
hey,
did
Sue,
you
did you? Not sure.
uh, I'll go ahead and mute you again, Susan. There you go.
Okay. Well, all right. Well, feel free to chime in again if you have thoughts. As we kind of go through this, I suspect that the underlying premise behind this is something that most of us are actually quite familiar with. And so I really find this topic just a really positive one. After working for years and years on the ground as a field agent investigating crimes, and particularly crimes against interpersonal crimes, so sex assaults and intimate partner violence and aggravated assault and that sort of thing, and watching sort of how it affected both the victims and the accused, and then the process and how folks ended up in the system and how long it takes. And it's just it also, the amount of time that it takes from an investigative standpoint, where there's not a lot of resolution, both from an investigative standpoint and then also from how victims and suspects feel throughout the process. And so that's sort of what turned me on to this topic in the first place, like some years ago. So let's talk about it. So this is just an overview of what I'm going to cover today. We'll just sort of kind of define it. What is it? And really, I guess in my mind, when I think of things, I like to know, well, how did this come to be, kind of thing. So I thought it might be helpful to understand just sort of the roots and understand what exactly happens in these processes, and then just to cover a little bit about how it's manifested in the criminal justice system as well as in higher education, and then some critiques of the system itself. So When we talk about defining it, there really is no one definition for it. There are several different authors that talk about it. I chose this one in particular because it really encompasses both the process and the outcome. A big part of restorative justice is accountability. And so, in looking at this definition here, the takeaway from this is essentially this is a process that is an inclusive process that really emphasizes that something bad has happened and requires repair. And so there are, as I mentioned, there's other definitions, but in a nutshell, I think this is a good one that really emphasizes how we hold people accountable, but we do it in a way that those who actually have, a vested interest are all involved in the process. And so I thought this was interesting because, if this is a group that, doesn't necessarily have a lot of familiarity with it, it's just nice to know that this is not a new thing. And it's actually, these programs are available in, yeah, even more than 40 countries in the justice systems. In particular, and I know I've got there that it's in the juvenile system as well as for intimate partner crimes. And so it started with juveniles, and then it has now, though, moved such that it's with adult offenders as well. And so the asterisk there behind it's used for grave crimes and lesser crimes is that there are some crimes and some instances where this process is absolutely inappropriate and not acceptable. And so when we think about repeat offenders or serial offenders, right? Like obviously, this is not for them. I know in the research, and I do a lot of work with sex offenders and repeat offenders, and one of the, obviously one of the critiques, and we can, we sort of talk about that later, is in the justice process and for accountability and rehabilitation and restitution and that sort of thing. And so I think that for some folks, I just want to be clear that it is great for a lot of crimes and a lot of instances, but it's not appropriate for all of them. So, and as of now, there are about 32 states that have support for a restorative justice program. So I think that's kind of cool. But with that, right? So we've got, countries all over the world, we've got, individual states that all have these programs. And because of that, it became sort of necessary. And so back in 2002, the United Nations, so the Economic and Social Council, really came up with what's called here the Declaration of Basic Principles on Use of Restorative Justice Programs. And so they just refer to it as the UN Basic Principles, with the idea that, with everybody operating, you know, individually, some countries doing some programs and some doing other programs, there should be some sort of, this is a universally social issue, and there should be some standardization in how we talk about it, recognizing that obviously legal systems are different, amongst countries, and that's fine. So what they really did here was they came up with, let's just let's just define, like, what are we even talking about? And so one of those is, to define what is considered a restorative process. And really what that means is it's just a process where the victim and the offender, and if it's appropriate, right, other members of the community will get together and they'll talk about the crime, and they participate together actively to try to resolve the situation. And generally it's with the help of a facilitator. And so their definitions are designed to be broad, because every country, and then, within the countries, the states have their own, it leaves them latitude for interpretation, but that's the general sort of definition. And as far as outcomes, are really just talking about what is the agreement that is reached amongst the parties as a result of having gone through these processes together. And the parties themselves are really, it's going to be the victim, the offender, and anybody else that may have been impacted by the crime. So in some sense, it's, community members and other relevant stakeholders. And so, so just in covering the definitions, that's kind of what we're literally talking about. I thought that it might be helpful just to understand, where did this even come from? And so while, the term restorative justice is a popular one, it's not, it is not at all a new concept. In fact, the underlying premise of this has been around for uh, decades and decades, and particularly amongst indigenous and tribal populations and religious factions. And the underlying philosophy is one of just basic conflict resolution. And so if you think about this, if any of you have kids, this is, and if you have siblings per se, right? Like I have two boys, and so when they were, younger, there is one sort of thought process behind conflict resolution. And if you've watched your kids and they've ever been, they've gotten into a fight, and all of a sudden, one kid ends up crying on the floor and the other kid, is, and there's an argument that ensues. And one way of handling this is that, you send the quote offender to their room and you say, I'm taking away all your electronics and you're not having any free time and you're grounded, and you just sit here and think about what you did. While, the other person, sort of goes and tends to their wounds and is maybe crying, and you can console them. There isn't much. That's not really a conflict resolution. There are maybe some parenting styles that do that, and this is not a judgment on parenting styles. It's just one way. Another way that some people tend to parent in a conflict resolution. So if you have a similar situation like that, the idea is, you bring your kids to a neutral environment. So let's go sit in the loft, and then you get to see the younger kid who was just body slammed on the floor and is now, bruised and upset. And the other kid gets to see the quote victim in here, get to see them crying, and then they get to talk about, this is how you made me feel, and this was so like upsetting and it hurt, and I asked you to stop. And then you get to hear from the other party that said, well, this is how I interpreted this, but I am sorry. I'm sorry that I did that. I won't do that again. And it allows for your sort of, the kid to see, here's what I did and here's how it affected this person. And then together, and if I'm there as the parent, as the facilitator, right? I'm gonna say, all right, to the victim kid here, um, what do you think should happen? What do you think would be, some kind of appropriate punishment? And inevitably, and sometimes, I mean, if any of you have kids, you know, if you ask the kid that, then they're gonna be like, well, they should have this taken away and that taken away and all these things. And so sometimes it's unreasonable. So you have to come to, an agreement here. And so I just bring this up as a to sort of underscore the idea that the basic premise behind restorative justice is not something that's entirely foreign to anyone that's had to deal with, whether it's kids or in the workplace or something like that. And so where this really came from, I think as I mentioned, is from some of our indigenous groups, and in particular, so there's really two hallmark programs. One of them was from the traditional Maori practices out of New Zealand, and they participated in what's called conferences, and I'll talk a little bit about that. And the other one is really the program out of Canada, and they participate in what's called these circles, and I'll talk a little bit about that. And so I think the idea is that as it affects a community. So a restorative justice process um, recognizes that, yes, a crime may have happened between one individual and another individual, but there's also the secondary and tertiary order effects that affect a community. And in particular, if it's not just an interpersonal crime, but, we talk about vandalism or theft or arson or, anything that happened. And so the notion behind this is that um, and what these, tribes and indigenous folks have really come up with is to think about it as a way to repair, the torn fabric of a community that has been really broken by this act that has happened. Um, and so together, we take those and they've come up sort of with this process. If we look back and think about also what sort of contributed to this rise is, in the 1970s, like restitution became like a big thing, and then victims' rights and support groups in the 80s really sort of exposed like the incompleteness, I will say, of the criminal justice system, such that it really focused on the offender. And so what I mean by that is, you have these proceedings in the justice system to determine whether or not an offender has violated the law. And if he or she has violated the law, then what should happen, right? Like what should be the consequences? And so, um, what that really does is it leaves, the party that is arguably the most affected by this out of the process, and that's the victim. And so, thinking about, huh, maybe there should be a better way. And so from a social justice perspective, also, it really touched on some of the just inadequacies of, the system where, um, when people, when folks go into prison, particularly the adult system, right, which is, really punitive. The juvenile system is rehabilitative. The goal is to rehabilitate so they don't end up, back in the system. Not so much with the adult system, it's just punitive. And so there's a lot of just suffering that goes on, and there's a lot of just egregiousness that happens there. And so the idea would be, is there a way to minimize the one, the burden on the system in the prisons, and the impact? And then is there a way to, okay, when these folks have served their sentence, can we do something, to get them back in a pro-social manner into the community? And as it stands now, there's not a lot, but this program, it does incorporate, some of the ideas that would help, to reintegrate our folks, back into the community. And so we think about, all right, now let's talk about it, right? So what are these processes, Jen, right? So in the mediation, the victor offender mediation, is, probably something that most of us are at least familiar with, if in a lot of things. That's not just like a law or justice thing, but mediation. But it's, the victim comes together with the offender, um, and basically they discuss the crime, they discuss what happened, and then they discuss the steps that they want to take to come to a resolution. And in this, there is a facilitator that's there that really facilitates the process, so that at the end of this, they come to an agreement. Um, a lot of times, as in my experience, I've heard, the way that it seems to work best is that the victim will prepare a statement ahead of time, and sometimes the offender does. It's, solely sort of up to them, um, and then they come to an agreement, and that is really the key. As you'll hear me probably touch upon a couple of times, is that there has to be, an agreement at the end of that. The When we talk about conferencing, and I mentioned this before, as this is from the traditional Maori practices out of New Zealand. So conferencing includes a few more people. So it's going to be your victim, and your offender. But in conferencing, it also invites affected family members, of the victim and the offender, as well as representatives from the criminal justice system. And so the same premise applies, where, the victim gets to say his or her piece, and the offender, will apologize, and then together as the group, they will talk about in a conference what the appropriate and agreed upon steps are to come to a resolution. Circles is, it's really in the research, it talks about, circles is the most involved and inclusive process, because it brings together the victim, it brings the offender, any family members, and stakeholders, and also members of the community that may have been affected by the crime. And sort of, this is based out of, in Canada. This is, one of the models that they really use. And so essentially, as the name might imply, people sit in a circle, and they start, at one person, and they just go clockwise, and each person has an opportunity, to say their piece until they can, collectively, the group can come up with, a resolution that everyone agrees upon. And so there's not It's not to say that any one of these processes is better than another, they're just different. It allows for some flexibility, just dependent upon, the type of case and the type of situation. So, it's, entirely sort of up to you, if you will. Um, I'm gonna take a tactical pause here just to say, does anybody have any questions or thoughts before I move on?
There's a couple of questions that came in real quick. What are some of the most not popular, common crimes that this is used for? You mentioned theft, and I assume like sexual assault. Can you talk a little bit about the examples of that setting and how they resolve this?
Absolutely, and that's a great question too. So, in sort of I'll parcel it out to what's seen in higher ed, and then also sort of just in the justice system, for offenders. So, for juvenile crimes, it tends to be things like vandalism, theft, can be drug use and distribution. Um, and there are some then interpersonal, like aggravated assault types of things that happens amongst with the juvenile population. And so with the adult population as well, and in those same, literally the same types of crimes. In higher ed, probably the only addition to that is going to be things like academic dishonesty and integrity violations. But then they also incorporate, so lots of what we see in higher ed is lots of sex assault, intimate partner violence, damage and destruction of property, and those sorts of things. So a case, let's talk about like a case example. So a case example may be, frequently in sex assault cases, there's little, traditional forensic evidence that is going to help to discern whether or not someone has violated the law, because it's not whether or not, sex occurred. It tends to be, did the other party consent? And so and about 90% of the time, both parties are drinking alcohol, and so that exacerbates, the situation. Sometimes people honestly misremember how things happened. There's a lot of research that supports that, but at the end of after some kind of incident, you may have a victim that comes forward and says, "I was very clear that I told you or that I showed you, you should have known. I was very clear that I did not consent." And then you have an accused who says, absolutely not at all. Like, I was there, we were there, you were into me. Like, there was nothing. You never said no, you never pushed me away. Like, of course you consented. Okay. And so you really have to tease apart in this type of case, then, does a victim want to go forward and go through, if it was a timely report, getting a sex assault, forensic exam, do they want to go through an entire investigation? Do they want to have to go to trial? Is it even going to make it to trial? Because in lots of cases like these, there's maybe just not enough to charge the suspect, and even if they can maybe charge him, there's really not enough to go through and get a successful prosecution. And so, in a case like these, and I can just speak for, for the military, about 93% of our cases are ones just like this. And so they're really, really tricky. And then there's also not a lot of closure. A lot of victims opt to stop participating because they just kind of want to move on. And frankly, it's really scary, right? To have to go through the justice process and have to testify. And so, um, using a process like this would actually allow, now both parties to be heard. And it's in some later slides that I talk about it, but this would be the perfect type of case and situation where they could talk about, here's what happened. It does assume, like I said, that the accused does have to make an apology, and they can talk about how to essentially make this situation right. And it affords some closure to the situation in a manner that is agreed upon by both folks. And so for vandalism as well, it might be, a community property, and then you might get, a store owner or like a commercial owner or a residential homeowner, and together they would sit down and say, look, you just spray painted, you just egged my house, and it's an absolute mess. And now I can't clean it. I've got to repaint it. And so, then they will talk about, what's the appropriate level of, fixing this, if you will. Is it restitution? And in, some cases, yes, if you have to, get your house repainted, then so these would be kinds of the types of things. It could also be essentially, repairing property and that sort of thing. So there's no like one size fits all. Um, and it just sort of takes everybody's opinion into account. So that was hopefully the answer to that question.
No, no, that's good. But and the ultimate goal is to keep them out of the prison system, on the one side, and then on the other to help the victim get some closure. I see. Okay, yeah, carry on. Unless anybody has anything.
Other questions? Okay, awesome. All right. So, and I think this sort of just goes into, because I do get the question a lot. Well, so what is it you're talking about, offender making amends or having to apologize or what, like what really happens here? Because there's some folks that are, you know, critiques of this process and saying, it's not enough. It's never going to be enough. So, talk to me, exactly about what they do. And so there are really several ways. So the first of which is offering an apology. And literally it's got to be a sincere and a genuine apology. And so that's, I think, why many of them opt to, sometimes write it out in a statement. But then, second would be restitution, right, where the offender actually pays the victim back. And this could be in financial, literally just paying the victim money, but it might also be in, I think, as I mentioned, like either replacing property, repairing property. It might also be in community service. Or even if a victim says, I need certain services now that I can't do anymore because you stole my car and then you crashed it. Okay, well now I got to get my kids to school. I have to work. So you just became my Uber driver for the next, however long. So those types of things. And so the third, sort of the third form or way that an offender might make amends is through sort of like community service. And so if this is something that has impacted the community, then together the community can decide, these are the things that you need to do. It might be towards like a charitable organization or like a government entity. And it's, again, it's just going to be up to the community kind of to decide, here's how you impacted us. And here's how we think is the most appropriate way for you to account for your behavior. So those are kind of the most popular ways, I will say. Um, so I kind of just wanted to highlight here, what does this look like in the criminal justice system? And so it's really used, if you look at, all the literature and the research that's on it and out there, I mean, it's used in every part of the criminal justice system. I think the first use was really in a pre-sentencing preparation. And so, it's ultimately, and what I mean by that is that, so after there is a determination of guilt, sometimes the judge, sometimes it might be like a probation officer that's like responsible for pre-sentence investigation. And so at this juncture, what they might do is say, hey, I'm going to refer you to a restorative justice program. And so if the parties are willing to go ahead and to meet, and so ideally they can meet and they can come together and say, okay, this is what we feel like is the appropriate level of, restitution, if you will, or whatever the accountability will be, through a restorative process. And then they take that back to the judge and say, here, Your Honor, here's what we recommend, what do you think? And then obviously, ultimately, it's going to be up to the judge and how that works. And so used by the police. So with this one, what I'm talking about here is that so in some there's in some countries, not in this one, but in some countries, the police are actually given some discretion in how they decide to proceed really with a matter. So in New Zealand in particular, there's an act here. It's the Children, Young Persons, and Their Families Act of 1989, and so that's old. But essentially, the idea was it was a restorative alternative for police to be able to, divert youth away from the system, if you will. And so it basically offered the victims, the offenders, and their families an opportunity to say, hey, instead of going through the system in a full investigation, let's see if we can, have our mediation and sort of and work this out. And so, ultimately, the juveniles in these cases were required to make an apology, and then to provide sometimes restitution if there was, just depending on the crime and if they had to pay anything financial. And there was always a community service element that went along with that. And so since that time, there have been a number of countries that have adopted programs that are similar to that one. And the great part about that is that when they were able to successfully mediate the situation and come to a resolution, it resulted in a dismissal of charges. And so from both an offender and a, life track purpose, and also from a, victim community impact purpose, people's needs were being met. Um, and so as we sort of move on, as far as, prosecutors tend to have, certainly more latitude than police in being able to sort of divert matters after charges have been filed. And so it just depends on certainly like the legal system in that country. So we have a common law country here where, a prosecutor can continue to divert charges like up until, the trial. And so in these cases, they can opt to say, hey, let's, victim offender, if you guys are willing to meet, let's go ahead and meet and let's talk about this. And again, if we can keep cases and we can unburden the court system, we can unburden the prisons, and everybody feels like they have been, heard and listened to, we're in a good space. As far as judges, now obviously like judges have, the most, latitude in these types of situations. And judges have options in both like pre-trial diversion and as part of, a sentencing, I think, as I mentioned earlier. And so I know in some jurisdictions where maybe prosecutors don't have the authority to divert cases, but maybe the judge does. I know in Italy, for example, that is the case. But ultimately, the options available tend to be really helpful. And I know so there was mention too in one of the articles about the state of North Carolina uses this practice actually pretty frequently. It's pretty well known in their system, and so it's become routine. So that at the beginning of the court hearing processes, the prosecutor will actually invite any parties that are interested to say, hey, if you all are interested in this mediation process, I would like you all to consider it. And then the judge has the opportunity to explain, the benefits and also sort of all the ramifications and that sort of thing. So, and then they have trained court mediators. At least in this state, they are just volunteer trained court mediators that will go through this process, akin to that victim offender mediation. So not so much with the circles and the conferencing, but we talk about how it's used by probation officers and in the prison. So, in prison systems, the idea is that at times they will have, and I have actually seen this as well. So I worked in juvenile detention centers before, and so I have seen, where victims will come in and just talk about their experience, and so the inmates sort of get to experience and really witness what things have been like for that victim. And it also promotes just like a pro-social culture of conflict resolution. And so, prison systems, I mean, if you've ever been, in the juvenile system, fights happen all the time if somebody steals somebody's cookies. This is a big deal, and they really go fisticuffs about that too. So if there's a way in the system now to be able to start anything that's a pro-social way to navigate life, and positive conflict resolution is really one of those ways. Um, I mentioned Texas, since you all are in the great state of Texas. There is a program there that's the victim offender mediation dialogue program. And so what that is um, the victim can decide on his or her own if he or she wants to essentially go and talk to the offender and have a dialogue with them. And so it's a process where ultimately, the survivor wants to talk with the offender and talk about things. And it doesn't affect their sentence at all. It gives them an opportunity to go in, to be heard, for the offender to offer whatever he or she is going to offer. And so while it doesn't affect their sentence per se, um, it's the victim's opinion has influence on the parole, hearings. And so, to the point where at least some of the victims, after having met with the offenders, have decided that they didn't want to contest the parole at the hearing. And so, for what that's worth, it's, certainly interesting, that could be, an option. Turns out, some kind of, again, just closure and moving forward for all the parties involved. All righty. So I thought it may be helpful just to kind of mention here a couple of things related to the impact. And so when we talk about it reducing recidivism, is that by going through this type of process, right, it allows really the offender gets to see from the victim, how what he or she has done has really affected them, has affected their lives. And there are some and plenty of, antisocial personalities in the system. And so for those types of personalities, this isn't going to resonate with them because it requires you to be able to experience some kind of empathy. And that's not something that, folks who are antisocial really are good at doing. So barring that population though, they are it allows them really to just gain some empathy and to understand what it's like. And so the data show that they are less likely to at least perform that same crime again. It's not the end all be all, certainly, and it doesn't keep people from committing any crimes ever, but it certainly helps to really resonate with folks. And so anytime we can keep somebody from reoffending, is a good thing, right? Um, and so for victims here, for them, they report, in fact, both victims and offenders talked highly about this process versus going through the court process, because both of them actually felt heard, is what they said. And so the victim as well, has an opportunity to really be heard. There are so many cases where, victims might report a crime to law enforcement. I mean, worldwide, right? And just never really feel like they're actually listened to, and they never feel heard. And their biggest fear is always, is this person going to believe me? That's why, the majority of people don't report, is because they're afraid that they're not going to be believed. And so now you take them and put them into a setting where you have, an audience that is dedicated, and the person that says, I'm sorry and I apologize. So they are able to just sort of regain some control over their lives, and then, feel like they're heard. And it allows for some closure. As humans, we don't really do well when we don't have closure to a situation. And so, when things go to trial, even, if they make it to trial, and, what are the chances of, in sex crimes in particular, but even intimate partner violence, with domestic violence and strangulation, what are the chances that a conviction actually happens? And I will speak, from the military justice system, not great. And so then it sort of leaves, the victim in these situations like, well, so I just went through all this stuff. It was awful. And it's been a year and a half. And then you know, yes, it went to trial, and yes, they were, heard, and it was, judged by a jury of their peers, but then nothing. And so there's like no closure really to that. And it's really hard. I've talked to a lot of victims who've been through that process, and they really struggle because it's, and what do we tell them? We tell them, really, you put forth a lot of effort to this, and at least you got your narrative and your experience out there, and people heard you. And yes, that's helpful to a degree, but there's not that other part that's like, but I still feel like I've been wholly wronged, and there was nothing to rectify that. So in these types of situations, they really say, like, resoundingly, um, they just want to be heard, and they want to feel like, somebody has appropriately accounted for what their behavior was. We talk about it promoting rehabilitation and reintegration such that, when we are teaching, people who are the offenders essentially ways to understand empathy and to look at something from, somebody else's perspective, and then how to make their way back into a community and a system. So instead of going to prison, if they haven't gone to prison at all, just a more pro-social way to behave. If they are in prison, then it now allows them, again, we're talking about like positive conflict resolution, how to empathize with people, how to listen to people. And so that would be the goal. And it ultimately, allows the community to become involved to the extent that anyone is available and wants to be involved. And so that's, that's kind of a huge thing, especially nowadays with kind of a lot going on. So, I wanted to, oh, I'll pause for a second, Rhonda. Is there anything else that popped up, like questions or anything?
Yeah, but we can move on and then we'll just take them all at once at the end.
Okay, yeah, I think there's just like this one and maybe one more. So,
Okay, cool.
uh, so, so criminal justice system sort of one thing, and then we're talking about like higher education. And so there are a lot of these processes actually that have now been incorporated into higher education. And so the idea is that the institution, so any university can use restorative processes across the institution, like writ large. It doesn't just have to be. And so you see, I've mentioned there like three of the most common sort of areas when we think about universities, like student affairs, then there's academic affairs, and then just the organizational culture of a university as well. And so I think it's there's a lot of literature too on how if you want to become a restorative university, how you can also use these processes amongst your staff, as well as between staff members and students, but then staff to staff, and sort of what that looks like. And so like a lot of the programs tend to involve incidents that happen like within student misconduct, right? Because student misconduct falls within the student affairs. And so universities have trained staff members that can facilitate these meetings. And again, it's the crimes that we've talked about already, whether it's, academic dishonesty or sex assault, drunken driving, and it affects multiple students, or vandalism. There's a program at the University of Michigan that has it's a great program. And so there's this actually called, it's through the Office of Student Conduct and Conflict Resolution. And they have a range of what they call restorative processes. And it's sort of anything from um, like coaching, like conflict coaching, to facilitated meetings, to mediation, and just restorative practices in general. And it can lead to both informal and formal adjudication. So it really just sort of depends. Um, but it has worked really well for particularly sexual misconduct. And universities have the same types of sexual misconduct and sex assault that we see in the military. It's like one for one. And so I would think a university, having a program like this at a university would be absolutely incredible. And there are actually several. There's a myriad of universities that have restorative programs. I just listed these two here, obviously, because you all are in Texas. But I was glad to see that there are programs at UT Austin and UTSA as well. So there's a litany of information on frameworks for how to establish this and the benefits and that sort of thing. But I know in the interest of time, I'm not gonna go into that today. But it's out there. So I'm welcome if anybody has any questions. You want to hit me up at any time. Happy to chat about it. Um, I think the last slide is that nothing is all great, and we always want to look at the other side of it. So what are the critiques of this? And I think it's really, really important, as a member, somebody who's been part of the justice system, for 25 years. These are good questions. And so critics talk about the biggest issue is due process. And so when we talk about that, it's really that the informality of the restorative justice process for some really calls into question, and they're concerned about the failure of maybe protecting human rights and violating people's rights here. And there are really there's five really major principles under this, and this is another reason why the UN Economic and Social Council really came up with those guidelines to address some of these concerns. And so the biggest issues are with discrimination, um, the rights, of course, against cruel and unusual punishment, the right, to be presumed innocent until proven guilty, the right to a fair trial, and then the right to consult with counsel. And so in those UN basic principles, they talk about, and it really addresses these individually and says, in particular, when dealing with discrimination, whoever is going to be facilitating needs to be a culturally competent human who is objective and has no conflict of interest in their. When it's talking about addressing, cruel and unusual punishment, that's really the impetus behind saying, and in the guidelines, it says there that the resolution needs to be agreed upon and it needs to be proportionate. And agreed upon is really, one of the biggest things there. And so, in addressing sort of the innocence that we are all, assumed innocent until proven guilty, they mention that the restorative process is only brought to the table when there is enough evidence that the offender, essentially to charge the offender for the crime. And so it's just not randomly, picking people and saying, you know what, you pissed me off. So we're going through this thing and then you're going to have to do a bunch of community service. So they were saying that there's that. And so, um, and then of course we talk about, the concern about fair trial. And how they address that is to say that this process in its entirety is only based on the victim and the offender. Both of them have to willingly and voluntarily agree to participate in this. No one can be forced, and sort of null and void after that. And so, and it also mandates that they are well informed of the process, of the rights, what they're giving up, what they're not going to participate in, all of which is sort of the training that you would get as a facilitator to be able to kind of explain that. And then the last thing, of course, is the right to counsel. And it's clear that both the victim and the offender always have the right to consult with counsel prior to and even during, up to the restorative process. So it's not perfect. And as I mentioned, it's not it's not for all the crimes, really particularly egregious ones. And but I mean, I think it's on the upswing. The other kind of the biggest issue, the other one is just the legal status, because depending on what state, what country you live in, some restorative justice processes are entirely independent of the criminal justice system, and so and they don't have like formal legal status. And so, that becomes tricky, certainly when you're coming to like resolution and you think you might have resolved something, but then, then you also then get linked up into their criminal justice system. I know there's some indigenous populations like throughout the world, particularly like in Pakistan and the Middle East, that really sort of struggle with trying to implement, something like this. So I think I will stop there in the interest of time and see if we want to just talk about if anybody has any questions or thoughts. I'm all ears.
And for I do have a couple, and if anybody has, they can unmute themselves or put it in the chat or in the Q&A. But one question that came in, do we have any idea that if this were more of a widespread process, how much money it would save in the prison system? Have there ever been any studies on that about how much burden it would alleviate
That is a great question. I don't have the answer to that right now, but I am happy to do some digging for you. I don't know, because I'm thinking about it from a research perspective. There could definitely be a cost analysis, if you will, that's done. I haven't seen any of that in the research that I've done to date. Doesn't mean that it's not out there. Um, and I guess it might be difficult because it's hard to say, in these cases, would something, had it gone to trial, would somebody have been convicted for that? Or what would that have been? But I think it's a fantastic question. So it wouldn't be like a one for one, but there's got to be like a ballpark in there that, I mean, I could certainly find out because I think it's right at the root of sort
Yeah.
of one of the biggest issues, right, is the financial burden to it.
Right, yeah, and well, like you had mentioned too, the big business of prisons now, it's
Yeah.
privately run. And then one more is at what point in the process, say someone commits a crime, say they vandalize a store and break the windows. At what point the police come, they arrest them. At what point is this process offered typically? Is it before it goes to trial or is it before they're booked or how does that work? Do you know?
Yeah, I think in a lot, well, some of it is dependent, some of it's dependent on where you live and what sort of legal system you're working with. In the States here, as law enforcement, we don't decide, if charges go, and we don't have the authority, police don't have the authority to say, I'm going to divert this. That lies, prosecutors have a huge latitude there. So, I mean, if they, in a situation like that, what typically happens in that sort of case is, the law enforcement might talk to the prosecutor and say, hey, I got this case, and then they, at that point, can decide, is there enough to charge this offender? And then the prosecutor can make that decision and say, hey, well, do you want to talk about here? This would be the time. Do we want to, file charges? Do we want to, um, or do we want to, see if we can engage in a mediation process? And it will also depend on jurisdiction and state by state. So it would be, after at least minimal investigation, because there has to be enough to at least charge a suspect, right?
Mm,
So like something has happened. So like police have to do some work, ahead of time and then present it to, a prosecutor and say, hey, look, this is what I've got. What do you think?
yeah.
So that's
Okay.
kind of, that would be sort of standard. In the military justice system, totally different, and I won't bore you with all the uh the major hurdles and differences there, but yeah, I'll just, so from a civil perspective, or the civilian, not civil, civilian perspective, yeah.
Okay. Let's see if anybody has any questions, they can unmute themselves or pop it in the chat. And I think I got all of them. In the interest of time, we got 4 minutes left. I don't see anything else coming up. Oh, real quick, if communities wanted to encourage their governments or universities to adopt this process, is there any process, anything we can do as citizens to encourage this or that sort of thing?
That's a great question. As citizens, so I think, there's always if you're talking about, higher ed versus like the criminal justice system, like criminal justice system, more in talking with your legal, counterpart. So if you went to, the district attorneys, if you've got folks that you could talk to, even like state representatives, to see if, from a legislative perspective, the state may be interested. And so just, seeing if you can get appointments with your representatives in the state there. For higher education, I mean, That's would imagine really talking and starting with, the different offices in the university to see if, you could come together in a situation like that, whether it's, with, the dean of students or academic affairs, starting with one area and saying, hey, you know, what do we think? I know like at ASU, they put out these reports every year. I think it's called the Cleary report, and basically it's like a calendar report, and it talks about like all of the responses, like all of the fire responses, all of the crimes and that sort of thing. And so I would say that, using that to say, hey, it looks like, because it lists there like all of the misconducts, whether it's sexual misconduct or whatever, I would say that if you've got your university's data, and then you might say, hey, look, we're seeing this as a trend, and there are other frameworks that seem to be successful. Can we have a meeting like this just to talk about, would the university entertain something like this? It's a good bit of work to get it started, but if you have, I think, tons of universities have been exceptionally successful at doing it. So, I mean, I think, that would be the first place to start, though, is to try to get some engagement from, student affairs, dean of students kind of thing.
Okay, great. Well, I think that's it. Unless anybody has anything, I want to thank everyone for coming and joining us this hour. We will have this available online. And a humongous thank you to Dr. Steele. And I guess that's it. Everybody, have a great day.
Thanks for hanging out, y'all. Hope y'all take care.
Thank you. See ya.
Bye.